Once again, for those who don't have X accounts, this is not Hailey or Jason Broyles' first article regarding whether or not Sean McDonagh knows what he's doing, insofar as trying to set Aidan Carney up. I think that's actually the title of the story, Eddie O'Brien's protege, Sean McDonagh. All right. So this was his appetizer, okay? As Joe Keating awoke in his cell on the morning of April 2022, 1987, he lay back on the plastic slab that was his bed, looking up at the bars. I was going to say stars. And hearing the voices of other inmates echo off the high wooden ceiling of the 101-year-old York Street jail in Springfield. He remembered being interrogated the night before by U.S. Drug Enforcement Administration agents Edward K. O'Brien and Sean A. McDonagh. He remembered his arrest the previous day. 18 hours later, he'd still not been allowed a phone call or access to an attorney. The following account is Keating's memory of what happened. McDonagh did not return an advocate phone call on the matter. His boss at DEA Springfield Special Agent in Charge, John Reap, denied our request to interview McDonagh. Keating's memory of the previous wiretap conversations turned out to be accurate upon our review. The tapes and supporting legal documents. "You're under arrest," shouts McDonagh, who orders Keating to spread his legs and lean face first into the wall, then slaps metal handcuffs tied across Keating's wristbones. He shoves Keating in the direction towards the stairs, and they ascend with Keating in his stocking feet. Another plainclothes agent with a shotgun comes through the back door. "Who's he?" asks Keating. McDonagh responds that it's nobody. Upstairs, McDonagh pretends to place Young under arrest and leaves him in the room with the other agent. He reads Keating his Miranda rights and pushes him towards the staircase. Keating now enters that other world where there are no eyewitnesses but the police and the defendant, and therefore will not speak on the record about all of the details of his trip with McDonagh. To tell the full story, he says, would involve pitting his word against that of police officers. But suffice to say, Keating recently told the advocate the arrest did not come gently. The setup. 3 weeks later, on April 6, Keating's father dies in eastern Massachusetts, and he flies back to the Bay State to mourn with his mother and family. He gets a message from his brother and that Andrew Young is urgently trying to contact him. When they speak on April 21st, the conversation is again recorded. "Sorry about your dad," says Young. You're in Amherst. Let's go for a drive and a talk." Keating suggests they meet at a friend's house instead. After Young hangs up the receiver, he is recorded saying to someone, "How's that?" Young goes to the Amherst house and hangs out with Keating, smoking a little pot and making small talk for over an hour, according to Keating and others who witnessed the events of April 21st, 1987. Young, according to Keating, keeps bringing up the circumstances of 3 LSD deals that the two have engaged in. Suddenly, a housemate downstairs calls up to Keating that someone at the front door wants to see him. Sensing trouble, Keating hides his address book on the way downstairs and finds a large man in a pink polo shirt, salt and pepper hair, aviator frames with a badge that says Sean A. McDonagh, DEA. It's about our review of the documents. Keating is dumped in the passenger seat of McDonagh's Chevy Caprice. His hands are throbbing and he guesses purple from the lack of circulation caused by the tight metal handcuffs. He will later remember McDonagh yelling to him that he's in big trouble now and faces 20 years mandatory on a federal offense. "You work for us." Keating remembers McDonagh saying, in effect, that he knows everything there is to know about Keating and that the agency has information on him that goes back 3 years. At the time, McDonagh was at the wheel driving west on Route 9 towards I-91 Keating recalls. Keating remains silent until McDonald says he's sorry about his dad. Then he asks if Keating's mother knows what he did. Keating will remember a heated shouting match between himself and McDonald. Then McDonald tries a more soft-spoken approach. He takes the tight cuffs of Keating and reapplies them, this time with his hands in front. Keating notices deep grooves on his wrists, and now McDonald puts the cuffs on differently, causing the marks in his skin to slowly disappear. He'll remember McDonald saying that is the last favour he will do for him, and suggests that Keating instead will do... Hang on, I have to start that again. Keating instead will do him some favours in future working for the DEA. McDonald suggests that Keating will go back to Eugene and make buys and work off the charges. But Keating remains silent, saying only that he wants to see a lawyer. McDonald steps on the accelerator, weaving in and out of traffic, according to Keating, and tells him that he has only one chance or no deals will be made. While passing Mount Tom, looking out the passenger seat window, Keating stays silent. He'll remember feeling a poke behind his ear as McDonald screams at him, trying to make him talk. He was yelling, Joe Keating, now of Sonora, California, recently told the advocate. I went limp against the window. I was scared. I don't like guns or violence. It was in broad daylight with other people on the road, so maybe he got nervous too. I was guilty as hell, admits Keating, who says he probably would be doing hard time in a federal penitentiary today, if not for the mysterious 86-second gap in McDonald's cassette tape of his conversation with Young the night of March 1987. Meeting Eddie. Keating was brought to the DEA offices in the federal courthouse at 1550 Main Street in Springfield through an underground garage and elevator. It was there in an interrogation room that he met Special Agent in Charge, Edward K. O'Brien. He looked deeply tanned, wearing a Rolex watch, a crisp starch-plaid shirt, a gold chain, a new haircut, remembers Keating. He struck me as a coke dealer type. O'Brien, who was arrested last August 14th on charges of trafficking 117 pounds of cocaine on at least 2 occasions this past year, is unavailable for comment, according to his attorneys, Owen S. Walker of Boston. O'Brien was the top cop in DEA Springfield from 82 to 88. According to Keating, O'Brien asked McDonald, what do we have here? McDonald's answer was, as Keating remembers it, a stupid expletive who wants to talk to a lawyer. We didn't know where Joe was for more than 24 hours, a friend of Keating's told the advocate last week. The local cops, the state police said they didn't have him. The feds said nothing. Witnesses said he was taken by a couple of men. We didn't know who. But Keating did not go to jail, and here lies the most interesting part of the tale. After what he estimates were 30 hours behind bars and intense questioning at the hands of DEA agents O'Brien and McDonald, Keating was finally allowed to see a lawyer. Springfield attorney Stuart Graham was assigned the case under the Federal Defender Program. Keating's brother posted a $100,000 personal surety bond, and I'm not sure where the rest of that went. We have to skip here. Later on, June the 19th, 87, Magistrate Ponce ordered the government to produce for inspection by the defendant's tapes of all conversations intercepted during the course of this investigation in which the defendant participated. On July 7th, defense attorney Graham informed the court that the tape of the Oregon car ride with Keating and Young had estimated 69-second period of silence in the middle of the tape, and asserted that the gap contained evidence relevant to Keating's entrapment defense. Attorney Graham moved to have the original tape tested by experts to find the cause of the mysterious gap. Government attorneys opposed the motions, of course they did, claiming that the gap in the tape was caused when Agent McDonald trailing Keating in another car, went out of range of the transmitters to get to the Ramada Inn ahead of time. McDonald, who joined the DEA in May 1996, signed an affidavit under the penalties of perjury, swearing our efforts to do this temporarily brought our motor vehicle and the receiver beyond the effective range of the transmitter. In my opinion, the so-called gap or blank portion of the tape occurred as a result. Yeah, I'm pretty sure you get static in between if that happens. To my knowledge, at no time was this tape tampered with in any matter. The government's attitude towards emotions, wrote Poncer in his decision, and particularly defendants' counsel, desire to obtain an independent examination of the tape, was quite sceptical and condescending. The position was that defense counsel was fabricating an argument out of air and simply attempting to delay and complicate the case. Finally, the government agreed to allow the tape to be analysed by Bruce Koenig of the FBI, who Poncer called an FBI expert, highly qualified to determine whether any erasure had occurred on the tape. Could be reading this in the wrong order. According to a copy of DEA evidence from Form 7A, signed by Agent McDonald on 25th of March, the cassettes of Keating and Young's conversation in Oregon were processed as evidence non-drug, and were maintained by McDonough until May 5th, at which time they were turned over to the Springfield, Massachusetts resident officer, custodian of non-drug evidence. In other words, he gave them to Camille Gale, who also signed Form 7A, and just to fulfill the system of checks and balances required by DEA, no doubt to prevent embezzlement, tampering with evidence, or other abuses. The agent in charge of McDonough's activities, signed and approved the document. His name was Edward K. O'Brien. So the FBI concluded that after the original recording was produced, the cassette was placed in a different tape recorder, and the record mode was activated for approximately 86 seconds. Poncer called this extraordinary news, contrary to the government's previous assertion that the gap could be explained by the excessive distance between the transmitter and the receiver. Sean's got a little bit of experience fixing people up, I'd say, from this. On December 15th, Graham moved for dismissal of the charges against Keating, alleging that the deliberate destruction of evidence. This motion, Poncer later wrote, threw a spotlight on a glaring inconsistency in the government's own sworn evidence. Around the same time, Regali left the U.S. Attorney's Office, and Assistant U.S. Attorney Mitchell Denbin took over the case. On December 22nd, the government offered Keating a deal. If he withdrew his destruction of evidence motion and pled guilty, the government would recommend a reduced sentence. However, if Keating didn't withdraw his motion, the government promised to slap another more serious charge on him, resulting from his dealings with Young, carrying a 10-year mandatory minimum sentence under the federal law. When the defendant didn't play ball to help cover up McDonough's destruction of evidence, they got the grand jury to file a superseding indictment to try to punish him and force a plea deal, which is what's going on with the Karen Reed case. You think Sean McDonough's not aware that that's what's going on with the Karen Reed case, guys? Yeah, there's a bit of delusions of grandeur going on here, isn't there? I'm agreeing with you. It's like knowing some of this background kind of puts more in perspective. That actually does know what he's doing. In my opinion only, but it does feel like he does know what he's doing. And all the manipulating other people and his mods, he knows what he's doing. Joe was a good client, notes his attorney. I have a lot of respect for him. He said, no, let's litigate it. You got to respect that. He was facing a 10-year minimum. He had guts. Keating was given until January the 5th, 88 to cop a plea, but declined the offer. The grand jury slammed him with another superseding indictment on the higher charge of distributing more than 10 grams of LSD. Special agent in charge, John Reap of DEA Springfield, told the advocate that no discipline was sought against McDonald for either tampering with evidence or perjury resulting from his sworn statement. He said the matter was investigated by the U.S. Attorney's Office. Former U.S. Attorney Denbin, now practicing in Springfield, said, "At best I recall, what happened was that when the tape was being reviewed by the agents in Oregon, the tape recorder, a handheld, had the record and play buttons jammed together. In the FBI enhanced tape, you could hear voices in the background. One of the voices was that of Sean McDonough. We couldn't figure out which of the agents was handling the machine at the time, although all of them were listening to it." But Ponce called the facts, which led to the motion for dismissal due to destruction of evidence, acutely embarrassing. He cited a letter from prosecutor Denbin to defender Graham, admitting that the deal offered to Keating was based, at least in part, in our desire to avoid the necessity of litigating the outstanding motion to dismiss based on destruction of evidence. Ponce countered by citing the case law that ruled to punish a person because he had done what the law plainly allowed him to do is a due process violation of the most basic sort. Here, the court is faced with an extraordinary prosecutorial gaffe, wrote Ponce in his decision. A motion for dismissal is filed. Threats of very severely enhanced exposure are made explicitly to repress the motion. Ponce thus concluded, for the foregoing reasons, this court hereby recommends that the indictment against this defendant be dismissed. And Hailey writes that in the end, the judge did the right thing because despite the defendant being guilty, we live in America where corrupt scumbags, like scumbag cops like Sean McDonough, just like the MSP goon squad of Michael Morrissey in Norfolk County, just aren't allowed to do whatever they want. I'll be the devil's advocate here for a minute. Sure, Sean was a dirty cop working for a dirty agency, but but hey, the times are different then. This stuff happened back then because law enforcement got away with it. It doesn't make it okay. The truth of the matter is that Sean on the Golf acts exactly the same way now, like he lives in that world with the same rules that applied then. He forgets that the internet changed the score. The internet changed the score, and that scumbag corrupt cops is what brings us all the way out to the sidewalks in this case. So that's just one story about Sean, the DEA agent. And the only reason we bring it to your attention is for you to understand that he's well versed and well experienced at setting people up and having the local DEA protect him from any consequences. You may think it's okay to jam Total Boy out in jail because you don't like him, just as some of you think it's okay to jam up multiple other people in the Delphi case because you like Richard Allen, but you don't like the other people. Most of you should be well aware by now that it shouldn't matter who you like or dislike. Trying to get people jammed up in jail for things they haven't done is actually the wrong thing to do, where justice itself is concerned with the right thing to do. And so, in the reading that we just did of Justice Ponce's decision, I agree with Jason. That particular judge did the right thing.